Good afternoon. I'm Judge John Airwood, and to my right is Judge Jeff Carpenter. To my left is Judge April Wood. We are here to hear one case, Edwards versus Strata Solar, and we want to thank the clerk's office and the marshal service for their service with us today. And with that, we are prepared to hear from the appellant.
Good afternoon, Your Honors, and may it please the Court. I'm Suzanne Reynolds, along with my co-counsel Michael Elliott. We represent Rebecca Edwards in this matter. I'll be addressing the sex discrimination claim and Mr. Elliott, the disability claim. I would like 26 minutes for my argument, 4 for Mr. Elliott's, 4 minutes for rebuttal to come from my time. Your Honors, this case reminds us that the evil in employment discrimination often involves stereotypes. That's the lesson from Philip v. Martin Marietta Corp. Decided in 1971. In that case, Martin Marietta had an employment practice of not hiring women with preschool-aged children when it regularly hired men with preschool-aged children. In a per curiam opinion, the U.S. Supreme Court said that it is sex discrimination to have one hiring policy for men, a different hiring policy for women, based on the assumption that women with preschool-aged children would not be good workers. So they reversed the Fifth Circuit that had recognized an order for summary judgment with a further remand to the Northern District of Florida. Your Honors, over 50 years later, Rebecca Edwards is still fighting employment practices based on false assumptions. The allegations and the reasonable inferences from the complaint, which we accept as true under this procedural posture, support that Strata fired Rebecca Edwards because it believed that women who might have a child in their future are less committed to their careers than men, with or without that hypothetical child. This argument makes these 3 points: that because this case turns on the employer's motive, it survives a motion under 12b-6 when Edwards has alleged that Strata fired her because of its assumption that women who might have a child in their future are less committed to their careers than men. 2, that stereotyping women as less committed to their careers who might have a child is sex discrimination, not pregnancy discrimination. And 3, that failure to amend a statute, legislative inaction to amend a statute that already protects against sex discrimination is simply irrelevant in this case. On the facts, Your Honor, I know that Your Honors are familiar with the facts, but I would like to highlight in particular this fact, and that is Sunday, January 29, when Rebecca Edwards has a conversation with General Counsel in which the General Counsel realizes that this is a woman who might want a child in her future. Everything changed after that conversation. Your Honors, it's reasonable to infer that Strata believed before this conversation that she was someone who would not have a child in her future. She was over 40, she was unmarried, and she did not have a child. And before this conversation, everything is positive. She receives unanimous praise in her performance evaluations. The General Counsel calls her a model employee. She regularly meets with the General Counsel and discusses her ideas that would be commensurate with a Deputy General Counsel position. She has regular conferences with the DGC, discussing her role when the DGC assumes to the General Counsel position. Then The Strata learns that she might have a child in her future. The general counsel never has another positive word for her till her termination on March 3rd. After this conversation, Rebecca Edwards is so disturbed she immediately gets in touch the next day with the vice president for human relations. It is the reasonable inference. Rebecca Edwards states to the vice president, after she learns of the scope of the medical documentation that Strata wants, she relays that to the vice president for HR, and the vice president for HR sympathizes with her and says, I'll try to protect your job. Edwards works remotely for 5 days. She returns to the office on February 6th. By this time, this is really significant, Your Honors, by this time, she has supplied all the documentation of the reason for her absences. And the general counsel says, we don't trust you, we don't believe you. You're going to have to start over, prove that you're a worthy member of this team. In a later conversation with the vice president for HR, Rebecca Edwards says, that is not my understanding. I understand that men were never disbelieved when they provided documentation about the reason for their absences. And the vice president again sympathizes with her, acknowledges that the GC thinks she's lying even after receiving this documentation, and says, I wish he hadn't told you that he thought you were lying. Two more meetings with the GC on February 16. Rebecca Edwards confronts Strata, saying everything seems to have changed since January 29 about my future with Strata. And in fact, the GC confirms that, because he says, I don't know what you're talking about. I've never considered you for the DGC position, even though the facts show that when Rebecca Edwards was being recruited, the GC knew she wanted to be Deputy General Counsel, and he said, I'm going to not renew my employment contract at the end of 2023. The DGC will move up to be the General Counsel. There'll be a DGC position open for you. He also says, we'll tailor make a position for you, and says if you're still in the same position in a year, we will have failed you. But after he learns that she's a woman who might have a child in her future, he denies ever saying anything about the DGC position. February 28th, there's another performance evaluation that finds Edwards exceedingly professional. 3 days later, she's fired for the stated reason, you're not trustworthy, you're not a team player, completely belied by a finding of her being exceedingly professional 3 days earlier. Your Honor, that brings me to the first point. When a case turns on the employer's motive, it survives a motion to dismiss when she has alleged what that motive was. The false assumption that a woman with a child in her future is not as committed to her career. In the 64 paragraphs of Edwards' complaint, she alleges with specificity a claim for wrongful termination in violation of the policy against sex discrimination articulated in the EEPA. The success of that claim depends on why Strata fired Edwards, and Edwards has alleged Strata fired me after realizing that I was a woman who might have a child in her future. Your Honors, the complaint, in fact, when you read the complaint, you are left with the question, what else could be the motivation for her firing? if not this false assumption about a woman who might have a child in her future. Your Honor, this case is particularly inappropriate for a motion to dismiss. As recently as May 2025, the Supreme Court reversed the Court of Appeals for affirming a dismissal under 12b-6 and reminded us of this, Your Honor, that when we're reviewing a 12b-6, you ask, do these facts raise any claim for relief? Do the facts alleged in the complaint support that all the elements of that claim? And 3, are there no facts that necessarily defeat that claim? In another case in which the Supreme Court reversed the Court of Appeals for affirming a motion, the grant of a motion to dismiss, the court added this. On that first element, the first thing we review the facts to see if the complaint alleges a claim for any relief. It does not matter if that claim for relief is mislabeled. If there are the facts support the elements of this other claim and no fact necessarily defeats it, there should not be a successful motion to dismiss. That brings me to the second point I'd like to make in this argument, Your Honor, and that is what we have here is sex discrimination, not pregnancy discrimination. More specifically, we have the kind of sex discrimination based on false assumptions about a woman who might have a child in her future, that they are not good employees if they're also mothers.
I have a question. How do you parse out the difference between sex discrimination and pregnancy discrimination when, in fact, to my knowledge, only females can become pregnant? So how do you parse out the difference there?
Your Honor, it is a case for sex discrimination. It is a case for pregnancy discrimination if the focus of the case is pregnancy. But we have never recognized the law in this country that if a woman does not lose her protection for sex discrimination if just because somewhere in the facts there's a fact about pregnancy. With all due respect, Your Honor, Strata blows a smokescreen by saying that this is a case about pregnancy. And for that smokescreen, Strata wants you to look at General Electric v. Gilbert, and it wants you to look only at General Electric v. Gilbert. But Gilbert's not really relevant to this case, Your Honor. In Gilbert, here's a case, Your Honor, where we'd say the very focus of the case is pregnancy. In the Gilbert case, it's about employee benefits. Men and women at General Electric were getting employee benefits. Women wanted an additional one. They wanted disability pay, not only for these other kinds of medical leave. We want you to add to your employee benefit package. We want you to add benefits for maternity leave, which they did not have at that time. Now we have a case about pregnancy discrimination.
Well, Dean, your complaint talks about pregnancy substantially, but you're saying this claim 1 is not a pregnancy claim? Are you conceding that it is not a pregnancy?
It is not a pregnancy claim. Your Honor, the complaint uses the heading sex and pregnancy, but does not say it is a sex discrimination claim and a pregnancy discrimination claim. The heading is broad, sex and pregnancy. In another case in which the Supreme Court reversed the Court of Appeals for affirming a 12b-6 motion, The Justice Tyson, his opinion from the Court of Appeals was adopted as the opinion in a per curiam opinion by the Supreme Court was adopted in the Farm Bureau Mutual Insurance Company v. Hall, which I offered to you in a memorandum of additional authority. And in that case, Judge Tyson said this, he said, it is a claim that you should deny a motion for 12b6 if there is a claim alleged from the facts, even if that claim is mislabeled. I mean, it was only a heading in the complaint that said sex and discrimination. But if you'll look at the complaint under that general heading, sex and discrimination, if you look at paragraphs 47 of the complaint and 49 of the complaint, page 13 of the record, it says sex discrimination.
There's only 43 paragraphs in the complaint. Paragraph 39 reads, the opening segue to paragraph 39 reads, defendant wrongfully and intentionally discriminated against plaintiff because of her gender and pregnancy. The amended one?
Turn to page 13 of the record. Paragraphs 47 says the public policy of North Carolina, as expressed in the EEPA, mandates that employers of 15 or more employees shall not discriminate on the basis of sex. I'm sorry if I'm directing you to the...
I don't know whether, was there an amended complaint filed?
This is the plaintiff's complaint before... Are you on page 13 of the record, Your Honor?
I am now.
Okay. That is the complaint that's at issue in this case. The case on appeal from the Durham County Superior
That's
Court.
right. There was a Wake County case and then there was a Durham County
That's
case.
right. That's right.
That's my confusion.
No problem. So in 47 and 49, the allegations of the complaint say this is about sex discrimination. In that case, Judge, that reversed the Court of Appeals for affirming a grant of a motion to dismiss, Judge Tyson says it doesn't matter how the claims are labeled. And we don't even have a label of a claim in this. We just have a general heading that it's sex discrimination. We don't have pregnancy discrimination here. We have sex discrimination. And I have talked about the smoke screen by Gilbert. Martin Marietta is much more on point than the Gilbert case. Gilbert's just about employment benefits package. But, Your Honors, here's an even more powerful point that this case is not like Gilbert. Justice Rehnquist, Chief Justice Rehnquist, wrote the opinion in General Electric v. Gilbert. 1 year later, Chief Justice Rehnquist also wrote National Gas v. Sadie. And in that case, the employer had recognized, we'll give disability pay for pregnancy, and we'll give it for all kinds of medical leave. And when men and women returned from medical leave, they retained their seniority, except when women returned from maternity leave. And Chief Justice Rehnquist, in that opinion, said, this is not a pregnancy discrimination case. This is a sex discrimination case. When you have a different employment practice for men and women, coming back from medical leave, you don't lose your seniority unless you're a woman returning from maternity leave. Your Honors, think how much pregnancy was involved in that Nashville gas case. It's a case about maternity benefits. But even so, Justice Rehnquist says, this is a case about sex discrimination because you have a different employment practice for men and for women. Men returned from medical leave and didn't leave its seniority rights. Women did. In this case, Your Honor, pregnancy is almost irrelevant. We offer pregnancy only to show that now, because it's a failed pregnancy, now Strata knows that there might be a child in the future. Your Honor, the case that Edwards offers as the most on point is Archer v. Patton. In Archer v. Patton, it's a case from the Northern District of Georgia. The district court judge writing that opinion was faced with this. The defendant was arguing that this is a case about pregnancy discrimination. And the judge in Archer v. Patton said, and the discriminatory practice at issue in Archer v. Patton was, we're going to demote you if you're in this level of position. We're going to demote you if you get pregnant and you're going to have a child. We're going to demote you. The judge in that case, district court judge, writing the opinion said, this is not about pregnancy discrimination. This is about sex discrimination, because the focus of the case was not pregnancy. The focus of the case was, you're going to have a child in your future. So the district court judge said, we are not granting the motion.
Under what circumstances would a female that's terminated in an at-will state like ours be in a position where they couldn't always file a complaint to survive 12b-6 under allegations like that? Is there ever a circumstance?
Certainly, Your Honor. And if the plaintiff did not have every element of wrongful termination, that she was a member of a class, good performance before.
Well, good performance is not one of the elements, right?
It does adequate performance, wrongful termination in violation of public policy, that you are a member of this class, you have performed, you were terminated, people were retained under similar circumstances. In this case, it would be, see my time is up, Your Honor, may I have a moment to conclude?
Yes.
In this case, it would be that male employees with or without a child in their future were not terminated. Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court. I'll argue plaintiff's disability claim. My co-counsel told me that I had 4 minutes for my argument, and I try not to argue with this particular co-counsel. Your Honor, much like plaintiff's gender claims, what defendant is asking the court to do is impose a burden on the plaintiff that's inappropriate at this stage. They are asking through this motion to dismiss plaintiff to prove her case within the complaint. And notwithstanding that that's not a proper analysis at this stage, plaintiff's complaint clearly articulates her claims, and that, like many employment cases, that she had an unblemished and highly successful track record with defendant until the allegations that make up the complaint, which is that the defendant determined she was a woman who wanted to be a mother and had temporary disabilities. Essentially, Your Honor, in its efforts to avoid liability, defendant asked this court to make 2 critical assumptions about plaintiff's disability case. One, that she was no longer disabled at the time when the termination decision is made, which is essentially an argument at 12b-6 that her disability was not a motivation for her termination. I would argue that it is the improper time period to be having that discussion. And 2, that she did not give notice of her disability to her employer, which is a factual battle often left to the jury, But clearly, the typical landscape for that battle is discovery. And critically, Your Honor, at this stage, both of those assumptions are undercut by the clear language in the complaint. Your Honors, discrimination based on disability is a violation of North Carolina law. The NCEEPA prohibits that. The North Carolina Persons with Disabilities Protection Act.
Counsel, under your theory, is everyone who is pregnant, does that constitute a disability? Or does, and the next question is, does everyone who has a miscarriage, does that constitute a disability? Which seems to be somewhat the way I read your complaint on the disability section.
Yes, Your Honor. The answer, and what we look to, just like we do on a Title VII claim, what we look to is federal guidance on the ADA, on the Americans with Disabilities Act. And we provided the Conde case, which is a Fourth Circuit case, to Your Honors. Clearly, the answer to the first question is no. I mean, the courts have consistently held that pregnancy in and of itself is not a disability. However, courts, and this is the Conde case, courts have consistently found that while pregnancy alone is insufficient to state a claim under the ADA, complications related to pregnancy may be found to be impairments that substantially limit a major life activity. Your Honor, I would not claim that every miscarriage is necessarily a disability. What we have done in our complaint is articulated several health conditions that Ms. Edwards had that do qualify as a disability. She sufficiently pled that she put her employer on notice of that, and I'd point you to paragraph 29 of the complaint where she provides fully documented medical information. And she's clearly pled that her termination was a result of the disability. So
and not to cut you short, but you are in Dean Reynolds' rebuttal time now. Yes,
Your Honor. Again, we'd argue that at this stage what defendant asks is impermissible in terms of making assumptions about Ms. Edwards' disability claims, and we'd ask you to find in our favor, Your Honor.
Good afternoon, Your Honors. May it please the Court. Phil Strack for the defendant, Stata Solar, with my colleague Nate Pincook here today. We think this case is pretty straightforward. We think the plaintiff is asking this court to judicially rewrite statutes, including the Equal Employment Practices Act, which I'll refer to as EPA. But as context, it's important to note that the North Carolina courts have consistently rejected efforts to expand or redefine EPA. Obviously, the general rule is that employment is terminable at will, and the common law tort of wrongful discharge in violation of public policy is a very narrow exception to that rule. Courts have rejected expanding EPA in multiple different areas, such as adding hostile work environment claims, rejected, adding retaliation claims, rejected, adding disparate treatment claims, rejected, adding constructive discharge claims, rejected. This court has been very consistent in that. None of these are actionable because our state courts concluded that they were outside the scope of the language of EPA.
So would you concede that sex discrimination is in fact directly under the statute?
So sex discrimination is certainly listed, but this is not a sex discrimination case.
It's pled as a sex discrimination case of sorts.
It's pled as a sex plus pregnancy case. And if you look at the actual count, it's called sex and pregnancy. North Carolina courts have never recognized, under federal law, there are some claims called sex plus something else under Title VII or the ADA or whatever. North Carolina courts have never recognized a sex plus claim. What the plaintiff is trying to do here is get this court to expand EPA to add a sex plus pregnancy claim. If you look at the actual allegations, number one, pregnancy and another concept called familial status are throughout the complaint. It's the gravamen of the complaint. The plaintiff is complaining, I was pregnant, I got fired, I wanted to have a child, I got fired. Those might be claims under federal law. No one's sitting here today saying that it's particularly right to fire somebody over either one of those issues. But what we're saying is they're not included in EPA. So if you
what can you point me to the element, what element of sex discrimination is absent in this? Taking the allegations as true, what element of sex discrimination is absent in this complaint? At a 12B6, we're not talking about summary judgment here.
Correct.
We're talking about 12B6.
Correct.
What element is missing, can you tell me?
What I would address that two ways, Your Honor. Number one, it's what they've added. They've added sex plus pregnancy, and they've added sex plus familial status.
So if she just said, because I'm a woman, I was fired after I had a miscarriage, and they treated me differently than they did a male counterpart whose spouse or girlfriend or significant other had a miscarriage, that would be okay under your argument. Is that correct? It's the fact that she said I was fired because I had a miscarriage, and they later started treating me differently. Is that how you want us to parse your argument?
Right. She alleges quite clearly in paragraph 50 that she was wrongfully and intentionally discriminated against because of her sex and pregnancy. So she's trying to create a new claim in North Carolina law called sex and pregnancy, which does not exist. If you look at the allegations in the complaint that only deal with sex, there's only two. In the record on page 9, paragraph 26, it says it basically alleges upon information and belief, defendant's management did not make the same demands of plaintiff's male colleagues when they had medical appointments or requested limited remote work. And then on paragraph 37, the record page 11, upon information and belief, defendant's questioning regarding plaintiff's pregnancy, disability, and need for leave to manage health crises were not directed towards plaintiff's male colleagues and were not directed towards plaintiff's colleagues who were not afflicted with a disability. Those are the only two sex-only allegations in the complaint that I can find, both of which are pled upon information and belief. They contain no factual allegations. They contain no factual circumstances explaining the nature of that. And there's no factual allegations about how the plaintiff's situation was similarly situated to any male at Strata.
Well, correct me if I'm wrong, but I presume that men at Strata can't become pregnant.
Correct.
So isn't it disparaging treatment if the women who are becoming pregnant are treated differently than a male whose significant other has become pregnant? If this was a male saying my spouse, had become pregnant and I was treated differently.
Possibly, Your Honor, there's no allegations to that effect.
So if we take out the word pregnant out of her, some of her statements, without losing the context that she was pregnant during some of this time, you would concede then that she would in fact have a claim for sex discrimination?
So not necessarily. So in the Gillis case, which we've cited in our brief, the court made clear that notice pleading is not sufficient to withstand a motion to dismiss when an at-will employee brings a wrongful termination claim upon the theory of a violation of a public policy. So, Your Honor, what you're talking about is a hypothetical that's not pled in the complaint. It's nowhere in there. There are zero facts to support a sex-only discrimination claim in this case. Zero. And the two that come the closest are pled upon information and belief. And under the Gillis case, that's not enough. The Gillis case says you have to plead them with some level of specificity, and that has not been done. Every other allegation in the complaint revolves around pregnancy and familial status, and of course this notion of a disability. So whatever the, sure, are there sex discrimination, sex-only discrimination claims that can be filed under EPA? Sure. I've litigated some of them.
So is
This
it
is
your
not one of them.
contention that because she was pregnant, she couldn't have been discriminated against sexually?
No, what I'm saying is that she's claiming she was discriminated against because of the pregnancy, not because of her sex alone. And in fact, she's actually pled herself out of a sex discrimination claim because she alleges in the complaint that that the company, at paragraph 6, record page 6, I believe, she says Strata actively and aggressively pursued her knowing she was a female. And then at paragraph 38, record page 11, she concedes that the company told her she would have the same opportunity to compete for the Deputy General Counsel role as her 3 male colleagues. So she's affirmatively pled herself out of a sex discrimination only claim. So she's not complaining about unequal treatment regarding sex.
Isn't she complaining about the unequal treatment after the fact that she later informed the company that she'd had a miscarriage? And then until then, it looks like by my reading of the complaint, she said everything was great and wonderful and she was getting all the benefits that she'd been promised until such time as she had a miscarriage, and then the general counsel didn't believe the fact that she'd had a miscarriage and that it affected her.
Yes, that's not a sex-only claim. That might be a miscarriage claim, which doesn't exist. It might be a pregnancy-related claim, which does not exist. That's not a sex-only claim, and to the extent it could be made into a sex-only claim.
My next question then is, how can a male have the same claim?
If there was an allegation and there were specific facts alleged in the complaint that a male had some sort of health condition and was not fired, and it was similar, not obviously pregnancy, but similar, then you could potentially foresee, hypothetically, a sex discrimination claim being made out of that. That's not the allegations in this case, not even close.
So is it your contention then that a female can only have sex discrimination case if she's not pregnant?
No, if she's pregnant and treated differently than a male with some sort of similar health condition, maybe. We'd have to know what the facts are about that, what the male's condition was, what the circumstances were. And under Gillis, that would actually have to be pled in the complaint, and that's not done here. That's why 2 Superior Court judges tossed these claims.
Well, the first one was a pregnancy only, was it not?
Yes, but 2 Superior Court judges said, no, this is not a sex-only claim.
Well, no, the first one was you don't have a pregnancy claim. Isn't that what Judge Ammons ruled on? It was a pregnancy claim. It wasn't a sex plus pregnancy. It was a pregnancy claim. Was it not in the first one?
Well, I think there was an effort in the first one to cast it as a sex claim, but the judge concluded that the gravamen of the complaint was about pregnancy, and that's not an EPA, therefore it's not a proper claim. So in my opinion, in our opinion, 2 Superior Court judges have looked at this complaint. They got a second bite at the apple to try to improve the complaint, and the only 2 allegations that could arguably be construed as sex-only claims are pled upon information and belief, and do not meet the pleading standard of Gillis. Here's another thing. While we're talking about this particular issue, in the complaint, the plaintiff tries to list a bunch of executive orders and some state HR policies, et cetera, as being the quote public policy. Under this court's long line of cases, the courts have held, we've cited these in the brief, that the only source of public policy has to be express declarations out of the general statutes or the Constitution. So there's two important points about what this court and what the Supreme Court has said about this. First, it's got to come out of the general statutes or the Constitution. We can't make it up. So an executive order is not enough. State HR policy is not enough. It's got to come out of general statutes. Second, though, it has to be an express statement. An express statement. What the plaintiff is asking this court to do is redefine the word sex in EPA and to include other concepts. And that's not expressed. The General Assembly could come along anytime, and if they wanted to sort of reform the statute and try to address a situation like this, they could do that. But they've not done that, and in fact, they've had numerous opportunities, as we've cited in the brief, to add familial status, this notion of I was looking to be a mother, they didn't think I was going to be committed enough. Those are familial status claims. They've had bills to add pregnancy and other types of claims to EPA, and none of them have ever gone anywhere. And so what the law says is that if the General Assembly is aware of an alleged problem, which it is because people are filing bills to try to address this problem, and they don't address it and enact a law, then that's an expression of legislative intent that they don't want that to be the law. And only they can do that. Arguably, the state Supreme Court could redefine the word sex in some form or fashion, but the lower courts and the superior courts can't do that. And so what the plaintiff is asking this court to do is kind of step out of its lane and rewrite the word sex to include concepts that are not there. And the law says that the expression of public policy has to be an express expression of it. It's got to have words. And the courts aren't free to just sort of redo it. I would also point out that most of these claims that have been brought in this case could have been brought under federal law. I do believe an EEOC charge was actually brought in this case, and then it was just not followed up on with a lawsuit. All these, so there's a remedy under federal law for all of these claims. North Carolina doesn't have a remedy. Reasonable people can disagree about whether that's good or bad.
North Carolina does have a remedy for sex discrimination, right?
If you plead it.
And so she has to plead, I was treated differently because of my sex, which she did here when she said, I was treated differently because after I had my miscarriage, so granted, she's no longer pregnant, so she's an unpregnant, not pregnant female. I was treated differently because of my medical issues after I lost my pregnancy, and because I could have children in the future, they treated me differently. It seems as though she's pleading the fact that she was treated differently because she had a uterus, and that is in and of itself something that's uniquely feminine. So how is that not sex-based?
Because it's a pregnancy plus familial status claim. And under federal law, those would fit very neatly under pregnancy discrimination and familial status discrimination, and that's what people would probably plead if they brought this to federal court, is they would say this was pregnancy, this was familial status. But more importantly, in order to actually plead a sex-only discrimination case, you've got to provide some facts under Gillis. You've got to show how male counterparts were treated more favorably. And there's zero facts in this complaint about that. In fact, it's all upon information and belief. And that's because there are no such facts.
Well, but isn't that your summary judgment argument, not your 12b6 argument?
Not under the Gillis case. Not under the Gillis case. Under the Gillis case, it says notice pleading is not sufficient in these cases. So under the Gillis case, it's not a summary judgment issue. It's a 12b6 issue. And there would have to be some allegation of how some male counterpart was treated better than she was under the circumstances that she went through. On the disability claim, I'll just point out that the plaintiff in their opening brief relies heavily at pages 33 and 34 on the Americans with Disabilities Act and concepts under the Americans with Disabilities Act. Again, what the law says is this has to be an expression of public policy in the North Carolina general statutes, not federal law. So the ADA is completely irrelevant to this case. Instead, the courts in North Carolina have looked to the Persons with Disabilities Protection Act to define what, quote, handicap means under EPA. And now, mind you, the plaintiff could have brought a claim under the Persons with Disabilities Protection Act and did not do so. But in any event, there are courts that have looked to the definitions under that act to define, quote, handicap. And handicap under or disability under the PDPA includes any disorder, condition, or disfigurement which is excludes any disorder, condition, or disfigurement which is temporary in nature, lasting 6 months or fewer, and leaving no residual impairment. There are no allegations in the complaint that I can find regarding how long the alleged medical conditions lasted. And an element of the claim under the PDPA is you've got to plead how long it lasted. That's not been done in this case. And it also only covers those who are presently disabled when they are terminated. And there's no allegation in the complaint that alleges that the plaintiff was presently disabled when she was terminated. By then, the pregnancy was over, the miscarriage was over, and there's no allegation that at the time there were any lingering, ongoing other conditions that were affecting her.
Mr. Schrock, you've mentioned Gillis 2 or 3 times. Could you remind us of the facts in that case?
Yes, it's Gillis versus Montgomery County Sheriff's Department. And I believe it was a termination case, and the court said at page 6 of the Westlaw opinion, talks about 3 exceptions to the at-will employment doctrine. It talks about the wrongful discharge, tort, and the court said that the complaint in that case failed to allege a violation of any explicit statutory or constitutional provision, or that defendant encouraged plaintiff to violate any law that might result in potential harm to the public. She just merely alleged she was wrongfully terminated for reasons that are against the public policy of North Carolina. And they made the statement that I've repeated here today, that notice pleading is not enough.
Did she allege that she was terminated because of her sex?
No, I don't believe it was a sex case. I don't believe it was a sex case. But we believe the same principles apply. The tort is the wrongful discharge in violation of public policy, common law tort. And we believe the same principles would apply to that. So I think it's important, we believe this is either a sex plus pregnancy claim, or a pregnancy claim, or a sex plus familial status claim. I've told you why we think that the disability piece of it fails. And again, when the U.S. Supreme Court came out in Gilbert and said, hey, sex doesn't equal pregnancy, the Congress amended Title VII to say, no, yes, it does. The General Assembly never did so. They never did so. And we know that they've considered doing that, and they've never done that. And then as the familial status claims, if the sex claims can be discerned as separate from the pregnancy claims, they are at best a sex plus familial status claim. The complaint is infused with these allegations. Edwards' plaintiff's allegations repeatedly refer to her as a woman who sought motherhood. Paragraphs 10, 17, 33, 38, 50. These allegations reveal this claim is not about sex alone, it's about sex plus family responsibilities, a category the legislature has expressly rejected. And there are no concrete facts that show discriminatory acts based on sex alone. The whole factual narrative in this case focuses on the pregnancy, the miscarriage, and the fact that the plaintiff thought that the defendant wouldn't want to keep her because she wouldn't be committed because she wanted to have a child. But of course, familial status is not protected under the EPA, and the General Assembly has had lots of bills filed to add that, and they've always been, they've never passed. And then again, any sort of sex claim, that is defied or belied by the notion that the plaintiff admits that they were aggressively pursuing her because she was a woman. The only thing that changed after her hiring was the pregnancy and the miscarriage. Her sex obviously didn't change. And it doesn't make any common sense or logical sense to say, hey, this male who hired the plaintiff because she's a woman would then 3 months later turn around and say, nope, I'm firing you now because you're a woman. No, the difference here is the pregnancy and the miscarriage, and those were the intervening events, and that is why the complaint focuses so much on that. So, in closing, I've always been taught you don't have to use all your time, and I'm hoping I'm going to not do that today. In closing, this case is not about enforcing a public policy. It is about rewriting it. The case illustrates why North Carolina's wrongful discharge tort is and should remain a narrow exception to the at-will employment doctrine. The legislature has defined the contours of public policy through EPA, and it has repeatedly declined to include pregnancy or familial status as protected categories. Plaintiff's claim asks this court to do what the General Assembly has refused to do, which is to expand the statute by judicial fiat. We believe both Superior Court judges got it right when they dismissed the case, and we respectfully ask the court to affirm.
Thank you.
Thank you.
Your Honors, in rebuttal, Edwards would like to make these 2 points: that we are not asking you to expand on account of sex in the EEPA, and two, that legislative inaction is irrelevant in this case. Your Honors, at the time EPA was passed in 1977, there was already Martin Marietta, the Phillips v. Martin Marietta case. Your Honor, the North Carolina Supreme Court has said on matters of discrimination, we look to federal law. So in analyzing what does sex discrimination mean under the EEPA, you have Martin Marietta. And in that case, remember that is the preschool age. When you have an employment practice, we're not going to hire women for this position if they have school-age children. That is sex discrimination. That was the law when the legislature passed EPA that specifically says on account of sex. Nashville Gas was already the law when, or about the same time, that EPA was passed, that it is sex discrimination, even if what's at issue is a maternity leave policy. The Strata says that the allegations of the complaint necessarily defeated because she was actively pursued, because she was a woman. She was actively pursued when Strata believed that she was not going to have a child in her future. That's the reasonable inference from she's over 40, she doesn't have a child, and she's not married. When they discovered that, then that's when everything changed. And Your Honor, we do have very specific allegations about you are discriminating against me on the basis of sex. In that February 16th conversation that's described in paragraph 38 of the complaint, Edwards says to the general counsel, everything's changed for me because you think I might have a child in the future. That is sex discrimination. And on the legislative inaction, the legislative inaction involves the two bills that Strata offers, saying you're supposed to draw some conclusion about those. Those two were the bathroom bill. And in those bills, it was proposed a laundry list of kinds of pregnancy discrimination. I see my time is out. May I have a moment to conclude?
You may have 30 seconds to conclude.
30 seconds to conclude. So the legislative inaction was not needed when sex discrimination was already specifically protected under EPA. Your Honors, thank you very much.
Thank you all both for good arguments, and please adjourn court.